Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. And whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Hey, good morning, everyone. Today is Tuesday again here on the Bottled Business Sense Show. I want to welcome all our returning viewers as well as our new visitors to the site. Welcome. Let us know where you're from here, whether you're watching us on YouTube or Facebook or just want to drop us a line. Just, hey, say hi. We'd love to hear from you. On the other side, we have Bill Bernard in our remote office. And today he has something of interest that you may be interested in hearing if you are an employer. So with that, it's a mouthful, so I'm going to just let him say it. Welcome, Bill.
Thanks, Rick. Rick has, past 3 words and Rick's out of the picture, All kidding aside, procedural, this is called procedural update when reporting sexual harassment in the workplace. Procedural update when reporting sexual harassment in the workplace. Some of this will be a little bit of review, but I need to go into that very briefly in order to bring you into the more updated versions of what's going on. This is an ever-changing field all the time. California is a very liberal state, and I'm not casting aspersions one way or the other there. I'm just saying that's the way it is. And employers, as much as employees, need to be aware of what's going on. So let's do a brief update. Both federal and California governments, federal and state governments, have enacted laws, as you know, that make it illegal for an employer to allow an employee to be subjected to discrimination of any kind, including sexual harassment. Federal law is governed by Title VII of the Civil Rights Act of 1964. And California is governed by the California Fair Employment and Housing Act called FEHA, F-E-H-A. So whenever you go in to see an attorney as a result of a claim of sexual harassment, they're going to proceed under one or both of those statutory schemes. When you go in and you complain or file a claim, you must do so either with an attorney or without an attorney. Under federal law, you go to the Equal Employment Opportunity Commission, called the EEOC. And under California law, you go to the Department of Fair Employment and Housing, otherwise known as the DFEH. They handle claims. An employee goes to these agencies to file a complaint, which is then referred to as a charge, okay? You file a charge outlining the general facts supporting your claim of harassment. You may file these charges with both the EEOC and the DFEH, or one or the other, doesn't matter. Now, why am I bringing this up? Because I want you to understand, excuse me, that when you proceed with these types of claims, before you even get to the litigation stage, you file a claim or a charge with one or both of these agencies to get the process started. You typically do that with an attorney or you do it on your own. Okay, I would advise to do it with an attorney. What's the next step when you file these claims or these charges? Well, an employer will be called upon to conduct a fact-finding investigation regarding the sexual harassment. The investigator from one of these 2 agencies, or both, listens to the allegations, makes notes, and attempts to identify all people involved and all witnesses, and then attempts to interview all of the people, including the accused employee. I would strongly suggest should that occur, that you have your attorney present. A thorough investigation should include interviewing all parties and all witnesses and any available documentation, which might include your personnel file, by the way. Employers, you must document the investigation and keep notes and statements from interviews with other employees and supervisors, and investigate any prior complaints against the person being accused of the harassment. So if Joe Blow is out there being accused of sexual harassment, you better know whether Joe Blow has been involved in any claims prior to that. And if he has, you had better have taken some disciplinary action or done something to document it in terms of appropriate action once you found out about it, whether that was to exonerate or to discipline the person in some fashion. So what do we have here as a recap? You have a claim for sexual harassment, and then you have the reporting of this claim or charge to agencies, either federal or state. Then you have the federal, state, or both agencies do an investigation with the employer. You have the employer doing a simultaneous investigation. How does that employer do this simultaneous investigation? Well, either by being made aware of it, of the claim by way of the EEOC or the DFEH, or beforehand being made aware of the claim by way of human resources, which leads me to the next point. You, as the employee, should have reported this incident or series of incidents, whatever the case may be, to the human resources department of your employer. Now, if your employer is too small and doesn't have an HR department, you had better have discussed it with your immediate supervisor or the owner of the company or both. So that's a process that I don't think we've talked about before, or if we have, we've skimmed over it. I not only want you to understand what's supposed to go on, you just don't, boom, go into litigation right away. But you need to understand what's supposed to go on, what's supposed to happen, what the obligations of you as the employee are, what the obligations of the employer are, and also, more importantly, even what is supposed to go on in terms of the government agency responsibilities in this whole thing, and potentially completing an investigation that might allow to an informal resolution. Maybe you don't have to go to court. Maybe you don't have to deal with all of this out in the public record, or maybe it gets expensive in terms of your legal fees. That's why this whole process has come about. So remember human resources. When you go to human resources, what do you need to do? I tell people this all the time. I bet you if I ask Rick, he won't know what to do, right? Because he's never sexually harassed anybody to my knowledge. But but Rick, what would you think you would do if you go and you meet human resources and you want to file a claim of sexual harassment? What do you think, common sense, what would a person want to do? In other words, would you want, if you're coming and reporting sexual harassment to me, I'm your boss, you can sit down with me, are you just going to come in the room, sit down and report it to me, get up and leave?
No, you want as much documentation to validate what you're saying and bring a buddy, right?
Well, you want to make sure you're on the right track. You want to take copious notes, make a diary, start a diary. You want to do what? You want to jot down the person or persons you're talking to as the employee. You want to jot down the date and time of the discussion. You want to put the substance of what is being discussed, okay, down in your notes. And you want to make sure you start this process in case you have to have more conversations, follow-up conversations. This then becomes a timeline, which then in turn becomes a diary. Every time I have a case like this, the first thing I do is draw out a timeline with the employee or the employer. Let's start from the beginning. Let's start, no matter how minute or inconsequential you think it is, let's talk about what happened and when it happened, and you draw out that timeline. And then if you're the employee, hopefully you have a notebook or a diary that corresponds with that timeline. Because even if you don't meet with your HR department every day, you want to put on what you want to put in that diary, what's occurring at your place of employment every day, if it in some way has some bearing on that potential lawsuit. And you know what? You put down, you're over-inclusive. You may think it's important, and maybe the attorney, when you meet with him, thinks, okay, well, this particular notation isn't. But let him or her make that decision, not you. Okay, now, a little bit of an update. California allows a relaxed burden for proving sexual harassment. Here are the summary of some key changes in the sexual harassment law. Number one, a single incident of sexual harassment is now sufficient to create a hostile work environment if the harassing conduct has unreasonably interfered with your ability to perform your work, or if it has created an intimidating, hostile, or offensive work environment. That's a matter of fact. That's a subject for factual determination. But it only takes one incident now, not a series of incidents or a continuing series of incidents over time. It only needs one incident, and it could suffice to be sexual harassment if it creates a hostile work environment. That is to say, if it interferes with your ability to perform your job functions, okay? Or if it is so intimidating, hostile, or offensive in some way that it makes your job unbearable. And that's going to be a determination that's going to be able to be made by either the attorneys involved or eventually a jury in a court. Number two, sexual harassment cases are rarely appropriate for summary judgment disposition. That means that they are a question of fact. 9 times out of 10, what you say is debilitating may not be what somebody else says. I shouldn't say 9 times out of 10, but maybe half the time. So in other words, you can't have the employer or the employee going in and making a summary judgment motion and saying, Judge, there's no questionable area of fact here. We presented all the facts to you, and you have to rule in our favor. 9 times out of 10, 99 times out of 100, they are not appropriate for summary judgment. It must go to a trial. Summary judgment is where a judge looks at a motion, looks at the facts you have recited, looks at the proof that are in support of those facts, and says, as a matter of law, there is no question here for a jury to determine. I'm going to rule in your favor. That is very rare in a sexual harassment case. Number 3, stray remarks doctrine. What's the stray, S-T-R-A-Y, remarks doctrine? Which previously found that a stray remark by a non-decision maker, some other employee, did not constitute sexual harassment. That's rejected. So if you're another employee on equal par with me and you make a sexual comment, it's not considered a stray remark anymore. It could be actionable if my employer knows about it and doesn't do anything about it. Number 4, this lower legal standard for sexual harassment claims should not vary by the type of workplace. This is supposed to be the way it is for any type of work environment. Okay, those are some major tweaks to the way the law used to be in California. So let's end the show by talking about new guidelines that work out in trial courts, something that you should be aware of should this claim or charge from the EEO that you make with the EEOC or the DFEH or DFEH becomes a litigation, becomes a trial. It's now more likely that even unwanted shoulder touches offered ostensibly as innocent gestures will survive summary judgment. Okay, so, you tap somebody on the shoulder or you give them a pat on the shoulder or grab their shoulder and say, nice job. You might do that to an attractive man or attractive woman. You may not think anything of it, but they may be offended. But here's the thing. It's their obligation to report that to human resources. Okay, so human resources, unwanted behavior must be reported to human resources in compliance with an employer's harassment policy. That should be laid out in a employer handbook. There are so many overlapping important issues here because we done shows, Rick, right, on employer handbooks.
Yeah.
You have to have an employer handbook that has policies laid out. And in that policy, a specific important policy should be what you do when you fear you are being the subject of sexual harassment. You report it to HR, you report it to your supervisor immediately so that the employer is aware of it. Because the first line of defense to a course of conduct, and when you're confronting a potential offender of sexual harassment, is please do not touch me anymore. Please do not do that anymore, or I'm going to report it to HR. Then if it happens again, you go to HR. If you don't do any of those things, the employer can say, I wasn't aware of this. I was never made aware of it. Now, you may try to say that there are reasonable circumstances whereby the employer should have known about it. But barring that, if you stay silent, it's not going to help your case. California, folks, has an avoidance defense that states that a company will avoid liability for harassment it does not know is occurring either by report or by reasonable diligence. So either you have to report it or by some reasonable diligence, they would have known about it without you reporting it. That, again, it's a situation of fact. Smart companies, as I said, have reporting policies that you should follow. You should follow as the employee if it exists. And that should be set out in an employee handbook. A key point of law is that the offender's proclaiming of innocent intention is irrelevant. The standard is whether a reasonable person would find the touching or the comment offensive, not what the intent of the so-called harasser was. And in a way, it's there for a purpose, but in a way, it's a little bit sad. You may have been raised, for example, as a very, I wouldn't say the word affectionate, but as a warm person. And what you do in expressing yourself may be the furthest thing from sexual harassment intentions. But if it's interpreted by a reasonable person, it could be interpreted that way by a reasonable person, then you're on the hook. And finally, the law protects you from harassment or job loss when you report sexual harassment, okay? This is important. If you report sexual harassment and you're fired because of it, that's called retaliation. That's a violation of public policy. And that in and of itself is a whole separate claim from sexual harassment. Very, very important. So I hope this has brought you a little bit up to date. It's a very important topic. We went into a little more detail than I thought I was originally going to. I kind of snuffed Rick out of the conversation there, but I wanted to fit this all in without making it too lengthy of a show. And I hope you guys got some benefit from it.
Absolutely. Yep. I totally agree. This is a very sensitive, very important topic. It's a very serious topic. And if you have any questions, please reach out to Bill in the contact information below. We have talked about this topic various times over the past few years. So take a look at our website at bottlebusinesssenseshow.com. And if you still have questions, reach out to Bill and I'd be happy to reply to you and start up a conversation, see how he can assist. So again, thanks, Bill, for your expertise. A very serious, very important topic to be mindful of. So
it really is. It really is. And, a lot of my career was spent in the employment law field. And the law has really changed over the years since I've been practicing. So it's coming up on, let's see, what is it? 32 years I've been practicing come this spring. So it really has changed, and it really requires somebody to stay on top of it. And I don't mean that in the literal sense. We like to have a little fun here, make a few jokes. Most people don't get them, and some find them offensive, but what the hell? Make sure you don't do what I'm doing now in the workplace. It's a good example. You don't want to say those kind of things in the workplace. That could be offensive to somebody, okay? So anyway, I hope you all have a prosperous week. And I think we can just end by letting everybody know where they can get a hold of us, right, Rick?
Yeah, absolutely. Information's below this video. Reach out to us on Facebook, Twitter, YouTube, LinkedIn, or bottlebusinessshow.com for our past several episodes on various different topics. So thanks again for joining us, everyone. We look forward to seeing you again on the next episode of the Bottled Business Sense Show. Have a great day.